Well, good evening, everybody. Tonight, I changed from the original program to talk about the Employment Rights Act. And the reason I've done that is because I think it's become increasingly important that people understand what's happened with the Employment Rights Act, but also what the dangers are of what the Tories and Reform um, are planning in opposition to it. So, let me just make a few introductory remarks. Um, when he became leader of the Labour Party, Keir Starmer negotiated a new deal for working people, is what it was called, um, which with trade union leaders as a central plank of their so-called partnership. What was promised was, in his words, the biggest upgrade in workers' rights in a generation. In return for this new deal, trade union leaders essentially agreed to stay out of Labour Party policy making. The bill received royal assent last December, but as I will explain as we go along, there is a huge consultation process that's still going on and will be going on for some time on the regulations to be made under the authority of the Act. Now, that may take another 2 years yet. Who knows how long it's going to take? Anyway, the fact is that Labour have reneged on the original deal that was done with trade union leaders. The proposals were considerably watered down. Although most of what trade union negotiators demanded was originally agreed to over a number of subsequent meetings, both with them, trade union leaders, and with employers' organisations, these proposals were watered down and watered down. On occasions, new versions were simply imposed with no discussion. For example, as the election campaign began in 2024, a revised version, rebranded as Labour's Plan to Make Work Pay, was simply emailed to leaders of affiliated unions. All trade unions, not just Unite, expressed their extreme opposition to the agreement being revised. And this was for the second time. Um, so a summit between the Labour leadership and trade union leaders was hastily arranged, after which all was declared to be fine. But suspicions grew that everything wasn't fine, especially as no lay member of any union was allowed to see that revised version. And those suspicions were proven to be well founded once a Financial Times journalist printed screenshots of the actual document. As the bill proceeded through Parliament, it has been watered down and watered down by the opposition in the Commons and in the Lords. Although some of it has now become law, many of the regulations are yet to be agreed. It is in these regulations, the nitty-gritty, if you like, that the effectiveness of these changes will be tested. So it has to be said at the outset that whilst the Act is an improvement in many areas, for me, it represents just baby steps towards better rights at work and rights for trade unions. I also have to say at the outset that I'm not a lawyer, so I may not be aware of some of the legal implications of some of the changes. However, let's have a look at the Act's main provisions. Going to deal with all 13 of them. Now, the Act itself was over 350 pages long. I've read all of it, um, and it is the biggest single piece of legislation on workers' rights ever printed in the UK. It is really comprehensive. So, in a short talk like this, I can only summarise its main provisions, which will inevitably be a thumbnail sketch of the legislation. It was introduced to Parliament in October 24 and was finally approved by the Commons in March 2025. Some of its provisions have now become law, whilst others will gradually be introduced over the next year or so. Now, in putting these 13 different provisions, what I've tried to do is group together areas contained in the legislation. But what you have to bear in mind is that some of these areas overlap. And also, as I go through them, they are in no particular order of importance. But the first one I want to start with is what I consider to be the most important. That is exploitative 0 hours contracts. More than 1 million workers in Britain are now on 0 hours contracts. That's an increase of 12% just in the last year alone. 25 years ago, it was only 200,000 workers. In other words, it's gone up more than fivefold in the last 25 years. Employers claim that it allows flexibility on both sides, and most of their workers want it. However, a TUC poll showed that 6 out of 7 workers on these contracts want regular hours. The poll conducted by the TUC also showed that over half of the respondents had had shifts cancelled at less than 24 hours notice, and that only 1 in 20 had been fully compensated for this. So a 0 hours contract basically takes away all of a worker's employment rights. They are trapped in an ambiguous contractual position where they can just be got rid of whenever it suits bosses. They're also denied the right to sick pay, maternity pay, redundancy pay, flexible working, and protection against unfair dismissal, for example. Things that they would have had if the original proposals had gone through. And I'll show you what the original proposals were in a moment. Employers like Deliveroo claim that those who work for them are not employees but are contractors. What was originally proposed in the deal between trade unions and the Labour Party was the abolition of the legal status of worker as distinct from employee, which would have closed a very important loophole used by employers. Currently, people at work are defined in law as either employees which I think most of us understand. That's the usual status of workers that we understand. But also as workers, that's people like Uber drivers or Deliveroo riders or truly self-employed people, although that status of self-employed is frequently abused by employers. Those who are simply defined as workers, which is now about 3.7 million working people, have no basic employment rights that employees take for granted. This change would have allowed trade unions and precarious workers to challenge the low pay, low security gig economy created by the Tories. However, the single status of worker was not legislated for, but consultation will start shortly. This means that if it is finally implemented, it will require primary legislation. In other words, the minister can't just issue regulations on this. At the Labour Party's National Policy Forum in 2023, trade union leaders were asked to vote on a revised draft of the New Deal. Incredibly, trade union leaders weren't allowed to read this amendment before voting on it. Even more unbelievably, 3 of the 5 biggest affiliated unions agreed to this totally undemocratic proposal, with only Unite and the GMB opposing the move. Allegedly, and I say allegedly because we don't know what went on in a closed meeting, allegedly Gary Smith of the GMB was then allowed to see it and subsequently withdrew his union's objections. The Unite delegation, however, walked out and have subsequently withdrawn some of their support for the Labour Party. They've cut their funding to the Labour Party substantially over this, the other things that the Labour Party have done in government. Now, that was the original proposal, and this is the revised proposal. It's no surprise that this change followed intensive lobbying of the Labour Party, of the Labour leadership, by both Uber and Deliveroo if the original proposals had gone through. A single status for all workers would have not just benefited gig economy workers, it would have also prevented the gig economy from undercutting the properly employed sector and removed the incentive for employers to replace employees with casualised workers. Furthermore, the original agreed version of the New Deal said Labour will ban 0 hours contracts and contracts without a minimum number of guaranteed hours. We will also ensure that anyone working regular hours for 12 weeks or more will gain the right to a regular contract to reflect those hours normally worked. And this was changed to banning exploitative 0 hours contracts and giving everyone a right to switch to a minimum hours contract. So, a couple of things here. Firstly, the word exploitative was added, but that has not been defined in the legislation. And so employers could claim that a 0 hours contract that they're offering is not exploitative. So effectively, this means there will be no ban on 0 hours contracts if employers can get away with saying in court that it's not exploitative. We all know how unsympathetic judges are to trade unions and the working class in general. The second thing to say about this is under this definition, the new definition, workers may have the right to continue to reject the offer of a regular hours contract, something that you can bet your life that employers will pressurize workers to do. In other words, there are insufficient safeguards to prevent workers from being coerced into not accepting the offer. So, in terms of the law, employers must now offer guaranteed hours to workers who regularly exceed minimums. So, after going through Parliament, 0 hours contracts are not banned at all, but simply the legislation introduces reforms to supposedly end the one-sided flexibility by granting qualifying workers new rights. So, as I say, employers must now offer guaranteed hours to workers who regularly exceed minimums. They must offer a contract reflecting the hours worked at the end of a reference period, which is anticipated to be 12 weeks for qualifying 0 or low hours workers. Secondly, employers must provide reasonable notice of shifts and pay compensation for cancelled shifts. So employers must give reasonable notice, not exceeding 7 days, for shifts and pay compensation for shifts cancelled or changed at short notice. It will be automatically unfair to dismiss or treat a worker detrimentally for accepting or rejecting a guaranteed hours contract or for bringing proceedings regarding these rights. So they can't just dismiss someone for bringing proceedings against the company. Exclusivity clauses are to be prohibited, and rights to the national minimum wage and holiday pay are upheld. In other words, exclusivity clauses up to now, some of these gig economy employers have said, well, you're contracted to us and you can't work for anybody else. Now, that kind of exclusivity clause is being outlawed. However, the specific details, such as the exact hours threshold and compensation caps, are still subject to future regulations. The reforms received royal assent in December last year and are expected to come into force in phases, with full implementation anticipated by 2027. Employers are advised to audit current practices and update systems to track hours and manage shift allocations effectively ahead of the 2027 deadline. The main point, though, about this is that 0 hours contracts are not banned by this legislation. The second one of the 13 that I want to deal with is strengthening tipping laws. What this provision follows from a number of high-profile strikes, especially by TGI Fridays staff, over changes to their tipping policy in 2018. The dispute began when the company started redistributing 40% of service charge payments made on debit and credit cards to back of house employees instead of giving waiting staff a wage increase. The move angered waiting staff who felt they were not properly consulted and would lose significant earnings, up to £250 a month in some cases. So, one tip, if you go to TGI Fridays or indeed many of these outlets, if you want to give a tip, give it in cash. Don't put it on the bill. That way, the waiting staff will get the tip. Um, but kitchen staff were also unhappy about not receiving a rise in basic pay because TGI Fridays said, well, you're going to get a share of the tips now. So that was what led to the strikes, and that's what's led to the strengthening of the tipping laws. So the Act now requires employers to consult with workers or their trade unions before creating or revising a written policy. So employers must engage with trade unions or directly with their workers if no union exists when developing or updating their policies. And these measures are expected to come into force in October 2026. These new consultation duties build on the Employment Act 2023, which already requires tips to be paid in full and allocated fairly and transparently. Thereafter, after October, tipping policies have to be reviewed every 3 years. This is to ensure, so that workers must have access to records of tip allocation for a 3-year period. Employers must also summarise the views of workers from the consultations. This is to ensure genuine engagement rather than just a box ticking exercise. And failure to comply with these duties may allow workers to bring claims to the Employment Tribunal, potentially resulting in compensation of up to £5,000 for any financial loss suffered. A government consultation on these specific changes was opened until the 1st of April 2026, with an updated statutory code of practice expected now later in the year. So the third thing is an end to fire and rehire. On an end to fire and rehire, rogue employers are purposely flouting the law. It's even contrary to capitalist laws of contract, which is supposed to be an agreement that's binding on both parties. That's why it's banned in many European countries. The very worst case was when P&O bosses sacked 786 seafarers on the spot in breach of collective agreements and statutory obligations, even using heavies, minders, to remove many of those workers from their workplaces before replacing them with workers on far worse terms and conditions of employment. P&O bosses were told that this was unlawful, but quite openly factored in the fine they were going to get into their costings. This was one of the greatest scandals in modern labour law history. Generally, fining employers under civil law doesn't work. Only making laws criminal laws for which someone might go to prison might deter them. But as I've said, P&O just built those fines into their costings. The original proposal that was agreed between trade union leaders and the Labour leadership said that any dismissal for failing to agree to a change of contract will automatically be considered to be unfair. After lobbying from the employers, there was a phrase added, except where there is genuinely no alternative. Well, as any trade union activist will tell you, this is a green light for employers to carry on doing the same, claiming that there was genuinely no alternative. Where fire and rehire was originally to be banned, a new version said that companies needed to be able to restructure to remain viable and preserve their workforce when there is genuinely no alternative. Now, I wonder where they got that from, the Labour government. Oh, yes, it was an argument that P&O had used, almost word for word, when they fired and rehired workers on worse terms and conditions of employment. So fire and rehire P&O style is not banned. The Act does restrict fire and rehire by making it automatically unfair in certain circumstances. It's unfair for employers to dismiss employees who refuse specific restricted variations to their contract, such as pay reductions, pension changes, hour reductions, or shifts. This aims to prevent unscrupulous pressure tactics. So, in other words, you can't pressure workers to leave of their own accord by such variations to their contracts. However, a narrow financial difficulties exemption remains if an employer can prove the changes were necessary to save the business and could not reasonably be avoided. So, whilst it's curtailed, it's not entirely banned. The threshold for justifying such dismissals is higher, particularly regarding financial viability, and employers are advised to finalise any intended contractual changes before the new rules take effect, or rely on genuine consultation rather than the threat of dismissal. Dismissals for non-restricted variations, like changes to job roles or locations, will not be automatically unfair, but will face enhanced protections, requiring meaningful consultation and consideration of the incentives offered. So there's no guarantee that the P&O scandal could not happen again. Employers replacing employees with non-employees, fire and replace, to perform the same work will also face automatic unfair dismissal claims unless they meet the same financial hardship criteria or the work needed has genuinely ceased. The new automatic unfair dismissal provisions and enhanced protections are expected to come into force on the 1st of January next year. The qualifying period for ordinary unfair dismissal claims is being reduced from 2 years to 6 months for cases involving fire and rehire. Up until now, you had to be employed for 2 years before you could bring an unfair dismissal case. It's being reduced to 6 months. Employers also face the risk of uncapped compensation for automatically unfair dismissals, alongside potential 25% uplifts for failing to follow the statutory code of practice. It's predicted that the code of practice will be entirely inadequate and will not end the scourge of fire and rehire as promised. The fourth thing is a code of procurement. When Labour were in opposition, they promised when they came to power, we would see the biggest wave of insourcing of public services in a generation. That's what the original agreement with trade union leaders committed the Labour Party to overseeing in government. However, the later watered down version said that once in government, Labour will choose to do business with companies that treat their employees well, recognise trade unions, and have provision for collective bargaining. Well, in our region at least, we know what outsourcing has meant for ancillary workers in the NHS because of what happened in Colchester and other places. So the Act amends the Procurement Act to introduce a statutory two-tier code. This is supposed to prevent pay and conditions disparities between transferred public sector workers and their counterparts in outsourced service providers, and to ensure that outsourcing cannot be used to erode employment rights or reduced pay and conditions for workers delivering public services. The code is due to take effect in October. And it requires contracting authorities and suppliers to ensure employees that are transferring from the public sector are treated no less favourably than the supplier's other workers, effectively mandating pay parity and similar terms and conditions. But they might be worse anyway, their existing workers. It applies to public service contracts involving the supply of services previously performed by the authority. So, for example, things like facilities management, social care, IT, as we're seeing with the proposals for Palantir, if you know all about that case, which we've been discussing at the Trades Council. Ministers will have the power to issue regulations. They'll have the power to issue regulations and a statutory code of practice to enforce these parity requirements. One of the things that you should bear in mind is, if you didn't know, codes of practice don't have the same legal force as regulations. They're simply guidelines. The fifth thing I want to deal with is guaranteed hours for qualifying agency workers. This provision, if it ends up being strong enough, and that's a big if, should in theory protect construction workers, for example, who are now almost always employed through agencies. The Act extends the duty to offer guaranteed hours to agency workers, placing the responsibility on the end hirer, not the agency, to provide a contract reflecting hours regularly worked during a 12-week reference period. This requirement applies if the agency worker is a qualifying worker who regularly exceeds the minimum hours specified in their contract, and the obligation continues until the worker no longer meets the qualifying criteria. The guaranteed hours contract must reflect the actual hours worked and cannot be less favourable than the terms the worker previously held, including pay rates comparable to agency terms or comparable workers. Employers must make the offer at the end of the initial 12-week reference period and after each subsequent review period if the worker continues to qualify. The duty can be contracted out only through a collective agreement with an independent trade union, and exceptions may apply for genuinely temporary needs as defined in future regulations. So workers can bring claims to employment tribunals for breaches with the power of the employment tribunal to award just and equitable compensation, while protections against detriments or unfair dismissal apply if a worker accepts or rejects the offer. And these reforms are not expected to come into force until 2027, with critical details such as the precise definition of low hours thresholds and notice periods still subject to government consultation and regulation. Now we come on to trade unions. This was on sectoral collective bargaining. This was the original draft that was agreed to cover all workers in all major sectors of the economy. That fair pay agreements would be negotiated through sectoral bargaining. Worker representatives and employer representatives would be brought together to negotiate fair pay agreements that would be binding on all employers and workers in the sector. That was the original draft. This was designed to arrest the alarming decline in the levels of collective bargaining in Britain. To give you some idea of that decline, in 1978, 82% of workers in Britain were covered by either collective agreements or a wages council order, whether they were individual trade union members or not. Today, that figure is just 28% of workers. Some trade union leaders argued quite rightly that the single most effective structural change that would strengthen the negotiating position of workers and their trade unions would be the introduction of sectoral bargaining across the whole of the economy, something that was originally promised. However, the final legislation only commits to sectoral collective bargaining and fair pay agreements to the adult social care and and school support staff sectors, while explicitly excluding all other sectors from this requirement. The reinstatement of legally protected collective bargaining in the adult social care and school support staff will be subject to consultation and regulations after engagement with the sectors. This was coupled with an extremely vague aim to, in the words of the document, assess how and to what extent fair pay agreements could benefit other sectors. In other words, it will be swept under the carpet. Employers in the adult social care sector must implement fair pay agreements to set minimum pay and conditions collectively. The Act also restores a school support staff negotiating body to facilitate sector-wide negotiations. As I said, the Act does not extend fair pay agreements to other industries, and the duty to bargain remains confined to specific enterprises rather than across entire sectors. Whilst unions gain a right to request access agreements for recruitment and bargaining, this doesn't create a universal right of access to all workplaces. So the government's plan to make work pay, intended to revive commitments to collective bargaining, but the final legislation restricted these powers to the two specified sectors rather than implementing a broader sectoral framework. And the interesting thing is that they haven't even extended this to all civil servants, their own employees. Furthermore, the way that sectoral bargaining is worded in the legislation, it looks simply like an extension of pay review bodies. Indeed, the Act actually states that agreements cannot legally be accepted as collective bargaining. The procedures are subject to tight ministerial control and veto. There are some, let's go on to trade union provision. There are some very comprehensive changes to legislation on trade unions and their activities. Now, it has to be borne in mind that since the 1980s Thatcher era, successive pieces of legislation have restricted the activities of trade unions to the extent that Britain has probably the most draconian anti-trade union legislation in Western Europe. So the Act repeals two pernicious acts by the last Tory government. These repeals have already come into effect. It has repealed the 50% threshold rule for strikes and repealed the right, in other words, what that threshold was, that there had to be a minimum of 50% of workers entitled to vote for strike action to take place. That threshold is now gone. And also, what has been repealed is the right of employment agencies to supply scab labour to replace workers when they're on strike. The worst of all, which was brought in 2023 by Sunak's government, required workers by law to scab on their fellow workers, whether or not they had voted for strike action themselves. In other words, under that Act, Minimum Services Act, if you voted to go on strike in the public sector and that public sector employer said that they needed a minimum service, like in the health service, for example, workers, even if they had voted to go on strike, could be compelled to go to work or face legal action. But whilst these acts have been repealed, none of the anti-trade union legislation imposed by Thatcher and Major in the 1980s and 1990s has been repealed. Now, if anyone tells you that these pieces of legislation that have taken place since Thatcher's time, that they're not unreasonable, ask those people if the same restrictions were imposed on employers' organisation, which they're not, would that be reasonable? Anyway, with regard to industrial action and balloting, no notice given to employers of strike action has been reduced from 14 to 10 days. The validity of a successful ballot has been extended from 6 to 12 months. In other words, once a ballot has taken place, industrial action can now take place up to 12 months after that ballot, instead of only up to 6 months after that ballot, when unions normally have to ballot again. The validity of a successful ballot is extended. Sorry, no, I said that. 40% support the threshold for industrial action has been removed. So this was for important public services, including education. So with regard to the 40%, this has been replaced by a simple majority of votes cast, which is the same for elections in any organisation. The workers are now protected from detriment, short of dismissal, for participating in lawful industrial action. And the previous 12-week protected period against automatic unfair dismissal has been removed. Now it is for the duration of a dispute. So you can't dismiss someone during any time during a dispute. Trade union access to workplaces. And I've put these two companies up here in particular. Many of the big multinational, especially American companies like Amazon and McDonald's, for example, have a history of using every dirty trick in the book to stop its respective workforces from organising in a trade union. The Act is supposed to make it easier for trade unions to recruit and organise in non-unionised workplaces, to simplify trade union recognition processes, to provide new rights and protections for trade union reps, a duty on employers to inform workers of their right to join a trade union, and additional protections from blacklisting. So the Act stops the likes of Amazon and McDonald's doing things to thwart trade union recognition. So trade unions no longer need to demonstrate a likelihood of majority support at the application stage. Although a 10% membership threshold remains, with government consultation on lowering this to between 2% and 10%, the employer tactic of setting up a bogus non-independent trade union to thwart recognition will no longer stop an independent union from recognition if it gains enough support. Also, employers won't be able to flood the bargaining unit with anti-union workers after the application for recognition has been submitted to the Central Arbitration Committee, because those workers, that non-union workers that they flood the workplace with, would not be counted in any ballot. Um, Trade unions gain a statutory right to negotiate workplace access agreements. This is for meeting and communicating with workers. If negotiations fail, the Central Arbitration Committee can impose terms and enforce compliance. Again, this is a watered down version of what the trade union leaders agreed with the Labour leadership. Trade unions were originally promised a right to access to employers' premises to meet, support, represent, recruit, or organise workers. All the Act does is provide trade unions with a right to request an access agreement for these purposes. If the request is denied, the union can go to the Central Arbitration Committee for an order to comply. If the employer still refuses, a union has to go back to the CAC for another order to comply. If the employer still refuses, the union can apply for a financial penalty. However, any penalty set by the CAC goes to the government, not the trade union. So unions have been granted a right without a remedy. Why would any union incur the costs of legal proceedings if employers can't be compelled to comply? However, employers must now explicitly inform workers of their right to join a trade union, and employers must provide reasonable paid facility time for trade union duties, with the burden on the employer to prove that these trade union duties are not necessary. So, also, there are additional trade union reforms and enforcement. Political funds, for example. The opt-in requirement has been reversed. This means that new members now are automatically opted in to paying the political levy of their trade union unless they choose to opt out. It was historically the case because trade unions spend a good proportion of their funds on political campaigning. For example, campaigning on legislation like this. In other words, they don't just use their political funds to give money to the Labour Party, as some people assume. It was Tory legislation that changed it to members having to opt in rather than having to opt out, hoping to starve trade unions of funds for political campaigning. And note that the huge sums of money donated by private companies to the Tory party, and now Reform, of course, are not subject to the same restrictions. I think they ought to be, especially foreign money being donated to Reform. A new Fair Work Agency will centralise enforcement of workplace rights, and trade unions will be represented on its advisory board. Also, protections against blacklisting of trade union activists has been extended to cover predictive technologies and AI systems applying to third parties as well as employers. Now, as many of you know, as an active trade unionist who was on the Economic League and Consulting Association's blacklist for more than 30 years and took successful High Court action against a consortium of employers, this is, of course, of special interest to me. Well, I won't go into the details here, but just to say that the existing civil law on this, especially when applied to construction workers, is very weak and doesn't protect most construction workers. The extension to third parties, such as employment agencies, is welcome, but the legislation is still weak. In the Blacklist Support Group, we've been campaigning for blacklisting to be made a criminal offence with much stricter criteria than currently exist. And that's something that Labour were proposing to do under Jeremy Corbyn's leadership that would have seen offenders jailed for breaching the law. And let's hope that if and when we get into Parliament, we campaign for exactly the same thing again. I'm sure Jeremy would support that. On the ninth thing, full employment rights from day one. As you can see from this, um, most of these changes have already been implemented. The cap on unfair dismissal compensation has been removed, but there is no date for implementation because the government are conducting an impact assessment. Um, However, again, there is a loophole for employers. The original agreement between trade union and Labour leaders said Labour will give all workers day one rights on the job by ending the qualifying period for employment rights. The later version, revised version, said that the New Deal would not interfere with the right of employers to make fair dismissals, including during probation. So here is the loophole. To avoid giving employment rights from day one, all that an employer has to do is to write probationary periods into contracts. And of course, that's exactly what they'll do. So, as you can see, protection from unfair dismissal will not be available from day one. The qualifying period was reduced from 2 years to 6 months in the final bill, with a potential lighter touch dismissal process during a 9 month statutory probation period for non-redundancy cases. However, the time limit for applying to an industrial tribunal will go from 3 months to 6 months. But that's, in other words, you up until now, once you've been dismissed after 3 months, you can't take a claim. That's been increased to 6 months. But that's far short of the 6 year limit for other contractual disputes. And that's not really much use for a worker who finds out that they haven't been able to get a job for years because they were blacklisted. It was 30 years from the time I was blacklisted until I found out that there was still a blacklist file held on me. So it wouldn't have been much use to me. Statutory sick pay becomes payable from the first day of absence, abolishing the 3 day waiting period and removes the lower earnings limit. Paternity leave. Previously, you had to have 26 weeks service, and unpaid parental leave, previously 1 year's service, have become day one rights. The right to request flexible working was already a day one right since 2024, but there will be stricter reasonableness tests for refusals expected in 2027. It was originally agreed with trade union leaders to give workers the right to disconnect and have time off, or, in the words of the agreement, a promise to bring in the right to switch off. Labour arbitrarily changed this to wishy-washy words like giving employers and workers the right to have constructive conversations and work together on bespoke workplace policies. Any trade union negotiator worth his or her salt would spot this a mile off as not being worth the paper it's written on. Also, the government has confirmed that they would not proceed with any legal guarantees on the right to switch off work-related emails and phone calls outside working hours. Certain protections have always applied from the start of employment, including rights against discrimination and harassment, whistleblowing protection, the right to a written statement of terms, statutory annual leave, and minimum wage entitlement, so that they are unchanged. The 10th thing, collective redundancy rights. The maximum protective award for failure to consult with a recognised trade union increases from 90 days to 180 days pay. So the Act introduces interim relief as a remedy for breaches by employers. The Act also introduces a new multi-establishment trigger for collective consultation duties. This requires employers to aggregate proposed redundancies across their entire organisation once a threshold expected to be between 250 and 1,000 redundancies is met, but the final regulations are expected by 2027. Consultation with a union is now required, if it's a recognised union, if an employer proposes 20 plus redundancies at one establishment, or if the total number of redundancies across all sites meets the new organisational threshold defined in upcoming regulations. The government is going to consult on a threshold number of employees. It shouldn't have been limited to one establishment. In other words, it should have been if it's 20 or more across an employer's whole business. Employers must consult with representatives of affected employees. However, they are not required to consult all representatives together or reach a single agreement with all of them. Notification requirements now extend to seafarers on ships providing frequent services to British ports, and that's regardless of the ship's registration. So employers are also advised to engage in proactive monitoring. In other words, to centralise tracking of redundancy proposals across all their sites to avoid inadvertent non-compliance with the new aggregate thresholds. A lot of this was needed because I've negotiated with employers that I've worked with, and they give you notice at the very last minute about the number of employees that are going to be sacked and a list of names. And they try every trick in the book to get round these requirements. So, also, the Act is introducing family-friendly rights. The Act is gradually phasing in what they call family-friendly rights. Already, paternity leave and unpaid parental leave have become day one rights, removing previous service requirements of 26 weeks and 1 year, respectively. Employees can now also take paternity leave and pay after completing shared parental leave and pay, a change that previously restricted this entitlement. There are also stronger protections against dismissal for pregnant employees and new mothers, which are scheduled to come into force in 2027, making it unlawful to dismiss a worker within 6 months of returning from maternity leave, except in specific circumstances like gross misconduct. Additionally, bereavement leave will be expanded to cover early pregnancy loss, where the baby is lost before 24 weeks, granting at least 1 week of unpaid leave for a miscarriage, ectopic pregnancy, and failed IVF treatment. Finally, a new day one right to bereavement leave for non-parents is also being consulted on, which is likely to provide at least 1 week of unpaid leave following the death of a close relative. The 12th thing, I'm getting there, there's 13 altogether, an action plan to close the gender pay gap. The TUC estimates that there is still a 13.1% gender pay gap between men and women. The action plan proposed in the legislation includes strengthening pay gap reporting. So employers with 250 or more employees will be required to publish equality action plans. The guidance applies to all employers, but the statutory obligation targets large organisations with a strong recommendation for smaller businesses to participate voluntarily. The plans must detail steps that companies are taking to reduce their gender pay gap and to support employees experiencing the menopause. These plans were voluntary from April 2026 and will become mandatory from spring 2027, and it will be subject to secondary legislation. Thirdly, employers must select at least one action aimed at reducing the gender pay gap and at least one action to support the menopause, although they are encouraged to adopt more ambitious measures. The government has published guidance featuring 18 recommended evidence-informed actions across 5 themes. The 5 themes are recruiting staff, developing and promoting staff, building diversity, increasing transparency, and supporting health conditions. Those are the 5 themes. And plans must be submitted via the existing gender pay gap reporting service alongside annual data. So employers should follow a 5-step cycle: understand the issues, select actions, submit the plan, track progress, and review progress annually. And lastly, a new single enforcement body called a Fair Work Agency consolidates the functions of those 3 agencies. So a single enforcement body has now been officially launched to try to streamline the enforcement of worker rights. It operates as an administrative executive agency under the Department for Business and Trade, guided by an advisory board comprising representatives from business, trade unions, and independent experts. Their primary role is twofold: to provide guidance and support for compliance and to enforce rights where necessary through dawn raid style inspections and legal action. Um, the, they have an expanded enforcement scope. They now can enforce statutory sick pay, holiday pay for the first time via state enforcement, minimum wage, and protections against labour exploitation and modern slavery. The Fair Work Agency can issue underpayment notices covering areas dating back 6 years, with penalties set at 200% of the underpaid amount, which is capped at £20,000 per individual, though this reduces also to 50% if paid within 14 days. It's a bit like parking fines. It possesses powers to enter premises, seize documents, and bring employment tribunal claims on behalf of workers who are unable or unwilling to act themselves. There are new record keeping rules. Employers are statutorily required to keep adequate records of annual leave and holiday pay for 6 years in order to demonstrate their compliance. There's stricter union regulation. Basically, it is the job of the agency to make it easier for unions to secure recognition by removing the 40% turnout threshold, as I said earlier, and the requirement to prove a majority of the bargaining unit supports recognition. And also to tackle workplace harassment. This includes strengthening employers' duties to prevent sexual harassment and physical, verbal, and mental abuse at work by taking all reasonable preventative steps, including against third-party harassment. As the bill went through Parliament, Tory and Reform MPs scoffed at this provision, with Reform describing most so-called workplace abuse as no different to pub banter. And that tells you what sort of people they are. As a trade unionist, this kind of behaviour has never been funny or acceptable to me. Physical, verbal, and mental abuse and harassment, whether it's by work colleagues, customers, service users, students, or patients, is getting worse because of the influence of right-wing politicians in the Tory party, but more especially in Reform, who have created a culture of acceptance of abuse at work. When it comes to abuse from the public, cowardly managers often use the tired old excuse that the customer is always right. Yet in a TUC poll, 79% of people support this policy in particular, making it one of the most popular policies in the Act. The main focus of the Act is to give workers individual rights to be enforced through employment tribunals, and is not by and large about restoring trade union rights. It isn't an easy process either, as you can see from this House of Commons library chart. I've taken 3 cases in the past through ACAS, and it is a minefield, so the novice can very easily be tripped up along the way. And the average wait for an employment tribunal hearing is 335 days from the claim being lodged. It's much longer for complex cases. And even if you win, research shows that about half of successful applicants are never paid their compensation by employers. In 2025, 75% of successful applicants using the government's employment tribunal penalty and naming scheme did not receive their awards. The extension under this new act of the time limit to bring an employment tribunal claim from 3 months to 6 months will mean it will take longer to get a claim heard at an employment tribunal. This chart, by the way, says still shows 3 months. It's been extended to 6 months. Nevertheless, in summary, as this whole bill went through Parliament, Tory and Reform MPs voted against it, including leaders Kemi Badenoch and Nigel Farage, despite the fact that 70% of constituents in both their constituencies support the Employment Rights Act. Farage vowed to scrap the whole of the Act, as well as the Equality Act 2010 and the Renters' Rights Act 2025, if, God forbid, Reform ever gained power. Their manifesto, and I've read their manifesto from cover to cover, proposes what they call a Great Repeal Bill. They have only mentioned this once since they proposed it and don't mention it anymore because they know that this is unpopular. Even their candidate in the Makerfield by-election didn't seem to know about it. So they must be stopped. You can get as many of these posters that you need from the TUC. Please get them and put them up in your workplaces or anywhere else that you think is appropriate. And the Equality Act, which I said they want to repeal as well, consolidates previous anti-discrimination laws into a single framework to protect individuals from unfair treatment and promote equality. Its main provision, its protected characteristics, it legally protects 9 characteristics: age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. They want to scrap all that. Prohibited conduct. The Act bans direct discrimination, indirect discrimination, harassment and victimisation across areas, including employment, education, and the provision of goods and services. In terms of public sector equality duty, public bodies must have due regard to the need to eliminate discrimination, advance equality of opportunity, and foster good relations between different groups. On reasonable adjustments, employers and service providers have a duty to make reasonable adjustments for disabled people to ensure they are not placed at a substantial disadvantage. On positive action, the Act permits organisations to take positive action steps to support people with protected characteristics who are disadvantaged or underrepresented. And in terms of equal pay, the Act enforces the principle of equal pay for equal work between men and women, including banning secrecy clauses in employment contracts. In addition to all this, the Reform Manifesto promises to leave the European Convention on Human Rights, joining Russia and Belarus as the only 2 other European countries to not sign up to it. In other words, they want to take away all our human rights. And in their Great Repeal Bill, they want to abolish the new Renters' Rights Act, which received royal assent only last year and came into force for private tenancies in England just last month. The legislation abolished Section 21 no-fault evictions and assured short-hold tenancies replacing them with assured periodic tenancies that provide tenants with greater security and the right to leave with 2 months' notice. So I won't go through all of these rights, but basically they're going to take away, if they get in power, all renters' rights. Um, but it's not just Reform that want to take away these rights. Many of you, like me, live in West Suffolk. And our local Tory MP, Nick Timothy, sent out a newsletter to all his constituents, sorry, saying that he will fight against the Employment Rights Act because it will make many local businesses go bust. Now, where have I heard that before? Oh, yes. The Tories said exactly the same when Labour introduced the national minimum wage back in the 90s. Not only did it not happen then, but it had the opposite effect. Local businesses thrived because they couldn't be undercut by rogue employers who pay very low wages and treat employees badly. And there are plenty of those, as you know, in this part of the world. They would do that if they could get away with it. So I've got a number of criticisms, but I won't go into those because I'm running short of time now, um, of the Act. Um, but I will just say that thank you for all of you coming along to some or all of my talks in this series of 10. I hope you enjoyed them. And if you missed any, you can see them on YouTube, as somebody asked at the beginning. Just type in my name and you will find them on YouTube. Also, if you want to know about my personal history as a trade unionist and political activist, you can get this book on Amazon. Um, I self published it 2 years ago, and it will be a great way for you all to say thank you to me for doing this series of talks for free to actually buy a copy. It's only £9.99. Um, I'm not saying this for the royalties because I don't make much money out of it anyway. I just think it might give you some idea and it might inspire you some things. Anyway, I thought after all my hard work, I deserve to be able to get a plug in. So thank you, everyone.